You look at the 2019 response, right? Minneapolis police pull him over. The officer draws his firearm immediately because Mr. Floyd is not showing his hands. And I know that in this particular case, Officer Lane did that exact same thing. It goes to the measure of the police response to that particular situation. So if we're gonna come in here and we're gonna have experts from Los Angeles and Montana and wherever else they're coming in from to say this was an unauthorized use of force, and you have a prior incident where officers used an identical use of force in an almost identical situation, that's where it becomes relevant.
Well, you can make your offer of proof. We can revisit it later, but I'll be honest, I'm not convinced. I could see where that evidence might be proper if you had said Mr. Chauvin was part of that arrest or knew about that arrest, and therefore when he had the contact with Mr. Floyd that resulted in his death, I could see where it'd be like, oh, this is what he does. I have knowledge that this is how George Floyd reacts to police interaction. But it doesn't establish that because Mr. Chauvin wasn't a part of that arrest.
Understood, Your Honor.
It's more of a generic, let's pick a situation because we have a body-worn camera and Mr. Floyd on it. There could be other body-worn cameras that show that that's not how the police react to it. So I guess I'm telling you right now, I'm not convinced yet to reverse my ruling, but I'll consider whatever you have as far as written offer proof.
Thank you, Judge.
All right, thank you, Mr. Nelson. Mr. Frere.
All right, we'll only briefly address that. I want to correct a couple of just factual errors if I can. The SUV contained 2 white pills that had distinctive markings, were unchewed, undigested, laying loosely in the center console area that contained methamphetamine and fentanyl. There was a pill fragment, a couple of pill fragments found in the back of the squad car that only contained methamphetamine. So I don't think we can say that those pills are exactly the same, first of all. In the prior incident, Mr. Floyd did not have to be physically restrained. He was treated by medical professionals when he admitted to using some pills on that prior occasion in 2019. He got medical attention at that incident. So some factual things I wanted to address, but
And Matt, I'm sorry, I want to check that second test of this.
okay.
Sounds like we have a discovery issue you can deal with later.
We have a second test.
Well, the bottom line is, it's not of consequence to me. I don't see, even if there are the similarities described by Mr. Nelson, that it is a modus operandi which is relevant, that establishes, that goes to any of the elements in this case. There's no prior relationship that it establishes or knowledge by Mr. Chauvin. Any minor probative value it has is certainly outweighed by its prejudicial nature.
Pure propensity, Your Honor. I guess.
Which is why I suppressed most of the states for the same reason, that it goes to propensity. Any case. Next, Mr. Frey.
So then, Your Honor, motion 35, we would ask the court to reserve this. I had asked counsel to try and narrow this down to specific records, specific items. I think we'll work on that. So I think we would simply ask the court to reserve motion 35.
Okay.
And then, Your Honor, motion 37. I don't know, I have no personal knowledge of what the National Prosecutors College is. I don't believe we have had any contact with them or sought any information from them. If it's, we have the rules of discovery that we have to disclose statements that relate to the case. And I think that, well, quite frankly, I think the court should just deny this.
What organization are you talking about, Mr. Nelson? I know that the National Advocacy Center used to be down in South Carolina, but that's been closed, so I'm not sure what organization we're talking about.
So it's my understanding that I've heard from other prosecutors, it's an organization that gathers materials relevant to expert witnesses and their testimony, copies of transcripts, things of this nature.
So you think that they might have collected something about your experts?
If they have, or even their own experts, that would be, I think, discoverable under the rules.
I agree, if they have collected it. Ms. Frank?
Whether it's this organization or a similar organization.
Ms. Frank?
To my knowledge, Your Honor, we have not obtained anything from this organization that counsel might be referring to. I'm not sure that if we did, it has to be disclosed. It would simply depend on what it is.
Well, I'm gonna tell you, if you got it, you're gonna disclose it. Whether it's from a prosecutor's organization or somewhere else where you've obtained transcripts, basically, because I'm familiar with the concept of the transcript banks. A transcript that could be used to cross-examine your expert or their expert, for that matter. Sometimes I know prosecutors will get it for their own to know what's out there that they have to defend against. So if you have it, he gets it. It's not work product.
It's not work product, Your Honor, but it may not be a statement relating to the case.
Well, that may make it not admissible, but I think this is a discovery issue.
So if an expert says something on the witness stand,
Correct.
right, that raises a question based on something they've said before, written before, it doesn't become a statement about the case until they testify.
Correct.
In terms of having to disclose it. So not.
No, I think it is, we're talking discovery here, not admissibility. You may disclose it and none of it's admissible because there's nothing in it. For example, if they give opinion A on the stand and there's a transcript, in another case they said not A, that's permissible impeachment of their opinion to go in and say, well, in State versus Smith, didn't you say X, Y, and Z, and now you're saying A, B, C. I think that's permissible impeachment. And if you have transcripts, I think discovery-wise, Mr. Nelson's entitled to that.
But what I'm saying is, until that witness says not A on the witness stand, that prior doesn't, I may be mixing up the court's analogy. Until that witness says A on the witness stand, not A isn't a statement about the case.
Correct.
It's potential impeachment.
Correct.
So there's no duty to disclose that until he says not, until he says A.
I'm telling you to disclose it.
And I assume the court will be telling the defense to do that as well.
Absolutely. If you have transcripts of somebody's, the other side's witnesses or your own, those should be disclosed. This is in federal court where you have to wait till cross-examination.
Your Honor, that is all of the defendant's motions we were prepared to address today. There are several of our motions that we could address. I don't know if the court wants me to
Well,
yield the podium or start in on those.
is there, can we talk about number 33, the Spark of Life, or did you want to wait for later?
I would prefer to wait, Your Honor.
That's fine.
I mean, Spark of Life is a very familiar topic to us all. I'm hesitant to start into it today because I'm not sure what the contours that defense counsel is thinking of with regard to Spark of Life testimony. To me, it's pretty straightforward, but I'm just not sure I know exactly what the problem is there. So we did not talk about it ahead of time, and
All right, why don't the two of you talk and we can address it later.
yeah.
Okay. All right.
So it's my understanding that the other defense motions that have not been addressed today, we will address tomorrow or as scheduled.
Subsequent days, correct.
Okay. Do you want me to start on ours, or do you want to?
Mr. Nelson, are you prepared to?
On the states, yes, I'm
Yeah.
ready.
All right. And if you could. Reference, I will assume on the state's motions that These are from the motions filed February 8th, 2021, unless you tell me otherwise.
That's my, that's what I'm working from, Your Honor.
All right, and these are also numbered, so if we can walk through the numbers, and let's start with things that are not contested that you've essentially agreed on.
I actually think that the vast majority of these will not be contested, Your Honor.
Okay.
With respect to witness number one, or excuse me, motion number one, we have no objection as to the permissible grounds for impeachment. Would not use a FBI report or a BCA report to impeach a witness who didn't prepare that statement. Number two is one that is going to be contested. It also corresponds to a subsequent filing that I don't have pulled up right now. But number two will be contested.
I think you're talking about the state's second amendment.
Correct.
That were filed on March 4th. Is that correct, Mr. Frank?
It is, Your Honor.
These-
Amended motion two.
Understood. Thank you. Mr. Nelson.
Thank you. Motion number three, Your Honor, I think is premature. I think that goes to the questions of jury instructions. Obviously would not make any reference to any rules of law that were not contained within jury instructions. But because we have not had a jury instruction conference yet, I think it's premature.
Mr. Frank, would you agree with that? And I actually need a microphone by you.
All right, since Beavis and Butthead is coming back, he said premature. Sorry, I had to do it.
Thank you.
Your Honor, the problem I have with waiting, of course, is we will have voir dire, we will have jury, we will have opening statements and witness testimony that could depend on what these concepts are and what they're going to be. So I don't think this is something we can reserve until the end of trial when we're looking at the final jury instructions. Because as part of our motion is, any testimony or argument about essentially incorrect standards of law. So I do think we need to address this certainly before opening statements.
Well, again, my strong position is nobody should be trying to instruct the jury on the law, because that's my job at the end of the case. And so if counsel starts to ask jurors their opinions about what does this charge mean, and use words like but for or intend, that's going to be problematic in jury selection, just to warn you. But Mr. Nelson, do you object to these, or what part do you object to?
No, I don't necessarily object to them, Your Honor. I just think that in terms of what the appropriate legal standards are, we have not thought about those, for lack of a better term. And so in that regard, Your Honor, it's not my customary practice to inquire as to the law or the rules of law in voir dire. And I rarely ever reference any sort of elements in an opening statement. So, I mean, it wouldn't be my intention to do this, number one. So if the court wants to grant it subject to a jury instruction conference later, that's fine too.
I think that's the best way to handle it. I'm going to grant it subject to the jury instruction conference, because I assume the state is relying on the substantial factor in causing death.
Correct. And we did submit a memorandum that addresses this motion too.
And I think everyone is in a safe harbor if you rely on the jury instruction guides for elements, generally. And so if these aren't in the jury instruction guides, you are in dangerous waters. So I'll grant it with the understanding that we'll talk about it at our jury instruction conference.
Sounds good, Your Honor. Number four, I'm just asking that we address that later in the week.
Okay.
Number five, I think is very similar to the one of our jury instructions. I have no objection to that, Your Honor.
Okay, that's granted without objection.
Number six, I think, is also part of our ongoing discussions about the training materials that both sides intend to introduce and the reasons for which they may be introduced, whether it to show that Mr. Chauvin received particular training or the policies of the MPD. And so that's just a discussion that we're continuing to have. I think we've made some substantial progress in that regard, and so just asking to reserve it, and if we need to come back to that at a later time.
Any objection to reserving it, Mr. Frank?
No, Your Honor.
All right, that's reserved.
Number 7, I have no objection to that, Your Honor.
Okay. That's granted without objection.
8, no objection.
Granted without objection.
9 9 and 10 are identical, and they are also identical to one of the defense motions the court
Right. I
previously
think we've
granted.
already established that you're not going to comment on each other's failure to call a witness. And if the answer to that was to call 400 witnesses, if this would not be a 4-week trial. Go ahead.
11, again, in terms of, I believe that the court has already issued its ruling on all 404B stuff, so it would be no objection to that, other than subject to,
Re-arguing the May 16th.
yep. Number 12, again, I have generally no objection to this. However, the state has agreed to provide me with the criminal convictions of witnesses, and if there is any intent to use any prior criminal convictions, we can cross that bridge should we learn of any.
Thank you. I'll essentially reserve that.
Okay, and I believe that's all of their motions.
Mr. Frank, anything else? We had the second supplemental, but that was basically the reserving on the expert.
Correct, just because we had obtained additional information from the time of the first motion to the second amended motion.
All right. So I didn't count them up, but we've got a handful of motions left to argue more substantively. Is that correct? I'll try and identify them myself. But that's it for today then, as far as motions?
Well, as far as motions, Your Honor, just other than stipulations as to strikes for cause.
Yeah, who wants to, somebody wants to take the podium and,
Your Honor, for the record, again, over the mid-morning and early afternoon break, counsel for the defense and state met and conferred and reviewed agreed upon jury strikes. We are in agreement to strike juror numbers 5 for cause, juror number 11 for cause, 12, 13, 14, 15, 16, 18, 22, 24, 25, 32, 35, 45, 47, and 50. We only made it through the first 50, Your Honor.
no, that's fine, that helps us a lot as far as who to call in. Let me make sure I've got it correctly. 5, 11, 12, 13, 14, 15, 16, 18, 22, 24, 25, 32, 35, 45, 47, and 50. Is that correct? State agree?
That's correct, Your Honor.
All right. Based on the stipulation, we'll release those people for cause. Since I think the parties are obviously being very thoughtful about the proper use of our time in jury selection by identifying these ahead of time, I may reduce the number of jurors we bring in from 16 to possibly 12 or 14.
Why?
The last trial we did in here in January, which was a murder in the first degree case, we were pretty good at keeping 6 per session, 6 in the morning, 6 in the afternoon, and getting to everybody. So I'm thinking this one we might be able to get, there might still be cause challenges that will be granted from 16. So my thoughts are 7 and 7. But if you have any advice to the court on that, I'm happy to hear from anybody. So, but I think for now we'll go with 7 and 7. All right. Is there anything else for the record today? You can't do it.
guess they're gonna end it already.
All right, anything further, Mr. Nelson? All right, we are in recess. Tomorrow, the jury has been ordered to report at 8:30. And so we'll try and get started with jury selection by 9 if we have motions at 8. So we will come back at 8. The jury is expected to start with selection at 9. And I'll start that with the basic group discussion or instructions before we go one by one.
Sorry, guys. I keep getting text messages.
As I've said to the state, unless the Court of Appeals tells me otherwise, we're going to keep moving. So with that, we're adjourned until 8 a.m. tomorrow. Thank you all.
Well, sorry, guys. That was quick. Hold on. Let's see. Let me go back here. All right, guys. So it looks like it's over. Hold on. I just heard something. This is crazy if this is true. Message deleted by the Google moderators. Of course, they keep doing that, guys. I don't know why they're doing this. What did you say? I mean, come on. That's weird. I gotta figure out what this Google stuff is. Tara just told me too that she's having the same problem on her channel. Even her stuff has been getting her personal speech has been violated. It's crazy. This is getting old, guys. Hey, Brownie. This is getting really old and sick. I just got kicked off of YouTube again on my backup channel because of some video that I showed, or some video that I actually deleted, so they couldn't even respond to it. But I guess deleting it doesn't help either. So I don't know what the heck's going on with YouTube. Looks like it's time to get my very own website. And I don't know what we're going to do. I'm going to have to figure out a way to get chat on there and get live streaming video. And it's not going to be cheap. So I got to figure out how I'm going to do that. And I got to talk to my brother. He's a businessman. He knows all this, some of this stuff. So we're going to have to figure something out. Then who knows? Maybe I'll talk to my buddies. You know, maybe, you know, well, I don't think Ben can come with me because he's with America's Voice. But maybe get like Will Johnson or freaking Oreo Express. You know, just get everybody that's conservative, get them off of YouTube and get them on my channel, right? We can do like a mug club type thing like the Blaze does, you know? Sell t-shirts, who knows? Yeah, I'm on Rumble right now. I'm looking it up, trying to get Rumble going. But who the heck knows what's going on? Who knows what's going on? What's up, God Rides a Harley? Haven't seen you in a while. I thought I had given you a moderator a long time ago. Well, you are now. There we go. So yeah, I'm thinking about getting off of YouTube. But then, you know, if I have my own website, then it's about how do I let you guys know that I'm live. So I gotta get like a, I guess I gotta get have somebody design an app for me or something. I don't know. I don't know what the heck we're gonna do. I was just filling out my forms on Rumble right now. Yeah, I know I need to get a server, so I'm gonna build a server here, but I only have 40 up, so that's not very fast. Oh, that's why I can't go live on Rumble. I've been trying it. Okay. So anyways, we're gonna figure something out, guys. I don't know what I'm gonna do. I honestly don't. But I'm gonna stay here as long as I can. And I have another backup. I have a backup channel that I gotta get set up. So I got a lot of stuff to do today and get ready for my trip to Austin, because I'm going to Austin tomorrow. My plane leaves at like 9 o'clock. So I gotta get going, guys. We will. Jeff Mack has his own. I'll have to talk to Jeff. I got some other buddies and stuff too, but I'm gonna have to figure out something. So I will talk to you guys later. I will be on tonight at 6 on this channel. I don't know if I'll change that light in time. I still got this stupid. Actually, if I go right here, it looks like God's shining down on me. Alright, guys. So I'll talk to you later. I got a lot of stuff to do. I got to get everything prepared for my dogs, for the babysitter, and get my luggage packed, and figure out what I'm taking, and download all my video, and upload video. So, right on, guys. I appreciate all your help. Oh, thank you, everybody. Thank you, everybody. I appreciate it. So, like I said, I gotta get going though. But we'll talk tonight at 6. I'll be live at 6 tonight on this channel. Just everybody be good on this channel, please, because if I get one more strike in the next 60 days,